Thank you. And as mentioned, we still have some copies down here in case anyone might want to take home, including Will's article. I think I'll use the virtual clicker like Will did, because that seems to have worked well.
Yeah, thank you.
It's kind of weird in this day and age.
Use a one for you, I get it.
Require a law student slave to do this work. I knew it was a mistake to go after Will Hornsby, so I unfortunately set it up this way. This is the last segment before a little more conversation. We've all been very excited about the possibilities of expressing legal knowledge in software, and having students build these brilliant applications that we can then deliver to the world. We talked about cognitive prostheses that can capture how lawyers think and enhance our reasoning. And as I mentioned before, there's the awkward question about whether, is this legal? Can we do this? Are there problems? Some people seem to think that putting this kind of stuff out there for others to use is an illegitimate activity. And it crosses the boundary into unauthorized practice of law. So that's what I'm going to talk about for a few minutes. And as one of the co-conspirators behind this Law Help Interactive project, which has become the big mothership through which a lot of this content is being delivered, I've got more than an academic interest, because I could probably be indicted in about 35 different states if, in fact, this is unauthorized practice, which is a crime in a number of locations. So we certainly embrace the idea of professional regulation for all kinds of activities that we engage in: taxi drivers, truck drivers, plumbers, electricians. Why should one profession be vulnerable to outsiders coming in? And according to what people like us have been trained to do, spent a lot of time being educated, being credentialed, being licensed, being regulated, why should a profession have to be subjected to this unfair competition? I'm talking, of course, about the teeth whitening industry. And as you may know, in many states right now, there's a big controversy, because there are a lot of people opening up shops to do teeth whitening without having any kind of dental credential. And the dentists are up in arms. Like, wait a second, this is what we do. We charge good money for this, and this is a very dangerous activity. We might really be hurt if their teeth are improperly whitened. There's an interesting study by a libertarian think tank about how the dental industry is thwarting competition. But just as a background to frame, for us lawyers, are we kind of acting the same way as the dentists are about teeth whiteners? Are the same kind of economics at play, or is there something special about what we do that makes us more or less vulnerable to outside competition? So in my article in the proceedings, I developed a number of scenarios about Sue Hilfer. Okay, Sue is an imaginary personality, but she's had a couple semesters in law school under her belt. She went through a bitter divorce, didn't finish law school, never got a law degree, never got admitted to the bar. But she made it her life's mission to help other people, other women particularly, to navigate through the divorce process. And I go through 20 or 30 different ways in which Sue explores, next slide, explores delivering knowledge about divorce. Certainly pamphlets and books and radio talks, TV appearances, videotapes. She goes through the entire gamut. The website, interactive software on the desktop, on a website. She goes down to the courthouse and sits in front and helps people. She even got a bunch of seniors together to put together a machine based on a pinball machine and a player piano and an old mechanical printer, put it at the courthouse that can generate forms for people who are going into the courthouse. So Sue's been an activist, and some of us, when we think about the boundaries of law practice, have people like Sue in mind, saying, gee, that's kind of activity we largely want to support. She's doing good things, she's promoting access to justice, she ought to be encouraged and supported, not prosecuted. Other people think about the opposite. Some folks who are anxious to police the boundaries of law practice are worried about sites like sueyourneighbor.com. This is imaginary, but probably not too. Right? And these sort of unscrupulous operators who are not lawyers, they claim, we're not lawyers, we're worse than lawyers. We help you, achieve your rights, generate complaints, give you guidance about how to maximize your recovery, and get revenge on your neighbors. So depending upon your mindset, which kind of player you have in mind, you may have a different basic instinct about whether this stuff is legitimate or not. Now, we're not talking about, for the moment, traditional service, where there's somebody sitting down with somebody interactively helping them analyze their facts or generate documents. Or even a co-production scenario where you're dealing with unbundled service, where both the service provider and the service recipient are involved in doing the work. But this third form of self-help, which is really situations where somebody with legal knowledge has found a way to embody it in software, in an artifact, put it up in the cloud or elsewhere where others can use it, and there's no contemporaneous relationship between these people. In fact, very often the recipient has no idea who wrote or created the thing they're using, right? And nor does the creator know who's using it or when they're using it. So there's kind of this separation. Does that make a difference in terms of how you characterize this? So this is actually a surprisingly complex topic that there's a lot of muddle-headed thinking about, I've discovered as I've read through cases and law-review literature and general discussions about it. And I think the fundamental source of that is that we have two contrary propositions that we respond to. The first is that, gee, if there's something you can't do in person, why should you be able to create a program to do it? Isn't that kind of just as bad? And you see some judges talking about, well, there was some human behind this piece of software. It didn't come out of the blue. So you can't disclaim responsibility for this product of your imagination. It's you acting through software. And if you can't do it yourself directly, doing it through software should be no more permissible. That's one attitude. The second is that, on the other hand, if it's something you could write about, if you could describe this in a book, or a set of charts, or outlines, or figures and pictures to explain to somebody how to do it, why can't you do that in software? I mean, books are free, right? We should have some freedom of expression. And we're torn between these two poles, these two contrary propositions that pull us in different directions. So a lot of people think about it, well, software is just a book. Some of us, including me, for many years said, it's just a different, it's kind of a fancy book, right? It's text. It's text that emits text. It's incapable of judgment. It's really something that's, as I said, mutually anonymous typically. You've got this sense that the program gives the same results to everybody at the same time. But what's different is it can be contextualized, so it can be dynamic. As somebody uses the program, it can ask questions, and it can respond, it can branch, and it starts to feel like, well, this is a little more than a simple book. And especially nowadays with advanced interfaces, and as John said, with Siri and Watson and other technologies of increasing intelligence, these things are going to start feeling very human-like and very unlike books. So, and the vendors of them describe them as expert systems and artificial intelligences, etc. So again, the old debate, in some ways the easy debate is, here's a typical book in New York, Norman Dacey's How to Avoid Probate, famous case. The New York Bar Association tried to shut it down because he was giving away the secrets to how to actually escape the probate process. And it went up to the highest court, to the Supreme Court or the Court of Appeals in New York, and determined to be, this is free expression. This is protected by the First Amendment. This is something you're able to do. It's a book, And so law is not being practiced, at least not in a way that anybody can prevent. Next slide. Question is, when you're creating software, is there a significant difference? Does software somehow take you out of the realm of freedom of the press? So in my article, I've got a number of kind of frames through which to think about this. This is not in the article, but you might find useful, which is we think of where these various forms of helping people, of delivering things that are useful to someone who needs to do work in their lives. You've got some that are in the nature of human services, and some that are in the nature of producing an artifact or a work of authorship, right? Some have physical effects, like power tools or medical devices, and some have informational effects. And the question is, programs, they belong squarely back in this quadrant where it's really like a book or a pamphlet, or is the fact that a program can produce effects, legal documents, legal relationships, and other things that can have significant impact on your life, does that take you more to the physical realm? Does that justify some regulation? Just a preliminary thought there. In the paper, next slide, I developed two pictures. One is just to understand the different modes of expression. And the basic branches between performances, which are things where you as a human are engaging in communicative activity either one-on-one or publicly. And then there are creations and works of authorship, traditionally books and pamphlets and other kinds of writings, but increasingly dynamic programmable material. And I think there's a very fundamental difference as far as how the law should treat it between the performances and the artifacts. Next slide. And this kind of captures the essence, which is a program more like a book, which should deserve protection, or is it more like a service that we think might legitimately be relegated to licensed professionals? And the trick is that it has aspects of both, right? It's a tertium quid, but it's got relationships to these others. So, like a book, a program is written in advance, it's canned. Once it's created, it doesn't change upon its being used. It is highly textual. It's, after all, a program is text and numbers, and producing various kinds of text. It's a work of authorship. But the service, it's bidirectional, it's dynamic, it's interactive. In the kind of applications we're building in these courses, it's generative, it's producing stuff. So it's like, wait, I can see how it can have the attributes of a service, and therefore may be subject to regulation. Next slide. So in the article, I try to make the claim that there are a lot of things that should not make a difference. And there's actually decent case law on most of these individuals. So the fact that you're doing something electronically doesn't change the essential character. The fact that it's online, the fact that it might be asynchronous or synchronous, how the interaction happens shouldn't make a difference. The fact that there's some interactivity and navigability inside of an application, we can jump around hyperlinks and answer questions and be taking down paths. In theory, that could be constructed in a book of arbitrary size. You could have a book that had every one of 10,000 possible permutations of the fact pattern and the associated forms. Whether it's phrased in terms of advice or not, just the fact that someone says, I would recommend, or for someone in your situation, my advice is. If that's in a book, no one would claim that's unauthorized practice of law. But somehow when it's being done online, people feel like that's closer to the human interaction. There's no distinction between free or paid. We can't take refuge and say, hey, all the good guys in the nonprofit world, we can do this, but those bad players that are out there taking away lawyers' lunches and doing arguably unscrutable behavior. When it comes to prior restraint and the First Amendment and freedom of expression, we don't make those kinds of distinctions, right? And under recent Supreme Court jurisprudence, corporations have every much right as individuals have when it comes to the freedom of expression. So, in conclusion, the premise is, are we free to code the law? And my instinct in law has always been yes, but after doing more writing and thinking, I'm more convinced than ever. I'm not sure I'm right, but I think there's a very strong case. So quickly here, crafting tools that helps self-helpers to understand their legal rights and obligations and accomplish legal work is a form of free expression. It doesn't need to be authorized. Freedom of expression, by definition, should not require anyone's authority, even if someone calls it the practice of law. So the question of whether something is the practice of law to me is somewhat irrelevant. You can call it that, it doesn't make it the practice of law. And even more importantly, it doesn't make it expression that is amenable to being suppressed. Thank you. So we have at least 10 minutes for interaction and questions and reactions. We thank you for your attention so far, and what does occur to you?
I was struck.
Hang on one second, let's get you a mic so we can, those that may be watching this on a webcast will hear you.
I'm Frank Snyder from Texas Wesleyan. What I was struck by your comments was that I think that the distinction that you're drawing between service and artifact is one that changes a lot over time. I don't know if you're familiar with work with Clayton Christensen.
Sure.
But things which once were extremely complex professional services are now pills, which can be purchased in a drugstore. And many of the things in my field, business organizations, for example, in 1870, to form a corporation, you went to Sullivan and Cromwell, and they drew up a bunch of documents, and they brought it through the whole system, and they crafted all kinds of agreements. Now you go online on a state website, punch in a few issues, enter your credit card, and you got a corporation. So I think that that distinction over the long term is going to be kind of difficult to maintain, although I think in the modern, our current situation, I think it has some resonance with a lot of people. But I think that a lot of what this conference seems to me to be driving toward is more a commoditization and an artifactation, to make up another word, of law practice.
Any reactions? Oliver, do you have a reaction to that basic notion of law moving in the direction of more and more intelligent and interactive aspects of the system being deployed in artifacts? Or Janina?
Yeah, and that's a good thing.
That's a good thing.
It's a very good thing. I mean, the idea that law has to be sort of on a case-by-case basis, and that each, I said it was a very good thing. The idea that law has to be done on a case-by-case basis would sort of comes out of a particular tradition of professions in the early 20th century. It's also tied to the adversary ethics. It's not nature. It's not what law has to be. And actually, if you think about law for 3 seconds, there's a lot of law that everyone knows that isn't about creating little difference and complexity. And so it seems like if we recognize that law, underlying law, is systems and think of that as commoditized, that's good, not a bad thing. Okay.
And I think it sort of identifies one other prime value of courses like this, which is it sensitizes law students to the fact that lots of what lawyers historically have done can now in fact be done quite effectively by machine.
I would take it even a step further. There's a lovely short article out there that you can Google, because I don't recall the citation exactly, but the title is something like, "Have you been Turing?" You know, Turing, the developer, one of the developers of the modern computer. And this article basically says that field after field, essentially, as the things that field is involved become computational, goes through a massive restructuring and becomes this other thing. So part of it is, have we been Turing? Well, I think we're in the middle of being Turing. But the other step of that is that also I would urge us to think that set of solutions and processes that we have called law do not exist because somebody with the big finger came down and touched somebody in a 3-piece suit. It exists because there are human problems of interaction and structure that needed solutions, and we came up with this system that we broadly call law as a way to deal with those. I would urge us also to imagine that we will find that they can be dealt with in ways that we would not call law. And that in fact, the whole thing we call law is subject to restructuring ways. So that if we can figure out a way to migrate the things we have done in the law into being done in other ways, if they're cheaper, more effective, why not? That would be a good thing.
John Mayer.
John Mayer, Cali, quick comment. So apparently, in the future, Google's driverless cars will be better drivers than all of us because they're not distracted, they're not sending texts while they're driving, they don't get drunk, things like that. And so we'll want them to drive our cars, or at least the insurance companies will. Matter of fact, maybe it will cost you more if you don't have a driverless car because you're a distractible human being. Are we going to be building systems that are better lawyers in certain situations than lawyers are because they can make mistakes, they can forget things, they miss deadlines? The software won't.
There's an old expression you heard back in the 70s and 80s when people began talking about automation law, that people would ask, are lawyers going to be replaced by computers? And the best answer has always been to me, the lawyers who can use computers effectively will replace the lawyers who can't. So it's not an either or, it's both and, of course. But I think increasingly the rise of non-biological intelligence, frankly, is the most significant development of our coming century. It's going to transform law in all of its guises, and we're just at the beginning of it.
You don't have to go much farther than checklists to deal with. I mean, the whole checklist phenomenon. There's literature about this in the medical profession. You don't have to Turingize us. You just have to have a checklist that says you ought to check all these things before you execute this document or sign this contract or enter into this deal. And that's enough, right, to justify the systematization that we're talking about, and that increases the quality and so on. And the other question, I mean, I've been thinking about that question about, are we going to make lawyers go away or automate lawyers? And my answer has always been that if you can, we must. Right? We're almost ethically required to do that. Because if you can make a machine or a pill or whatever it is that does a better job and can do this legal work better than we can,
Right.
then we are probably ethically required to do that.
Sounds good, we have a couple hands.
Drop that.
I actually wanted to push you a little bit, Mark, on this
Yes.
issue of unauthorized practice. And I've been I've been sort of going around and around about it for a while, and I'm completely sympathetic with all of our shared instincts, or maybe not all, but many of our shared instincts, that this is about freedom of speech, et cetera. But what I think that both this is in terms of the cases and the categories, is that what gets missed is a system. If you think about what being a professional is that you can be sued for malpractice, and so there's a safety net in terms of a negligence system. That's true of doctors, that's true of lawyers, et cetera. And what the question that leaves open is, if someone is harmed, what is there to help them? Here's an analogy. Excel spreadsheet, I'm sure all of you read, was the cause of the financial crisis. Surprise, right? I mean, there was a mistake. There's a flaw in it, and I can't remember the details, but that's, we're not suing Microsoft for, right? There's no redress. So it seems to me that this is a space where we might want to think a little bit about the harms that are out there that would hurt people using it. And I know, and a number of you know that, Stephanie Kimbrough's involved in some efforts to find certifications and best practices and sort of create an institutional presence so that people can tell who's good at this and who isn't. But I think we need to think a little bit more about that.
Yeah, I agree, there's no question there's a balance to be struck. There are significant dangers and harms potentially afoot, and we need to think of ways to adjust them. But again, we're talking about the transmission of knowledge and expression. And we allow books to be written about eating dangerous mushrooms and doing all kinds of other things. And we just need to be careful as legal professionals that we don't let somehow our self-interest and our sense of paternalism with respect to the public override our values about the importance of freedom of expression and exchange. And I think in the long term, a robust marketplace of these kinds of tools coming forth is probably the best way to achieve the most good. But that's a public policy question.
Yes.
The constitutional question is tougher, and anyway, I'm sorry.
I'm Marc Lesner-Fines, University of Missouri, Kansas City. As I think especially about the gamification aspect of this, I'm thinking about all the different things that lawyers do, the roles that they play, and those that are pretty easy to translate into technology, and those that give me some misgivings. And the gamification presentation in particular caused a kind of I love games. I love this. I would love to spend my entire life doing nothing but writing games about law. But it makes me feel a little uncomfortable that I'm doing something wrong when I do that. And I was trying to figure out what it was. And I think I have some beginning thoughts about it. Much of what we've seen about when we are using the law, technology, to translate law, are planning, the lawyer as planner, the lawyer as compliance, helping people comply, helping people plan, but less so helping people protect and helping people resolve. So when people are in conflict, in order for law to be seen as having the authority, having both the power and the authority to resolve that conflict, they have to accept that both the rules and the decision maker are legitimate. And there's a human process in there. Now, whether computers will be seen as more or less legitimate, as more or less agents of the rule of law, so that people will internalize that decision making as authority and thus cause them to moderate their behavior in situations of conflict, I don't know. That's kind of the open question to me. But the gamification is what where my thought on this all kind of started, because I thought, wow, I don't want to drive more people to think that law is a game that you play for winning. You know, it's sort of like that big lottery ticket in the sky. I've been looking for a good lawsuit, and by God, I finally found one, and I'm gonna make my millions. I don't want more of that, because I think that undermines the acceptance of the rule of law.
But it's okay with war?
No, I know, I went there too, and no, I don't think it's okay with war either, but I'm a pacifist, so what the heck am I doing being a lawyer? I don't know. Those were just some thoughts to kind of toss in another,
I know Oliver has at least a response, and maybe Will does as well.
My response isn't to the game side, which I'll absolutely will, but was to your assertion that dispute resolution is inherently human-driven. The online dispute resolution folks, with things like the PayPal and other dispute resolutions, are getting to success rates of amicable dispute resolution between 60 and 80% before a human intervenes. And what they've done is they've systematized the kinds of questions a good mediator would ask in order to get the issues in front of people, to assist them actually in solving their own dilemmas and taking them through that piece. Now, is there the residuum? Absolutely. Do we need the folks you're talking about? Absolutely. But I wouldn't necessarily assume that disputes are also unamenable to these kinds of processes. It's already happening. It's happening with high degree of success, and we're only 10 years into thinking about it. So I would say that all domains that lawyers and law have traditionally inhabited are subject to automation in some way.
We need to wrap up. It's after 1, but I thought I'd give Will Hornsby the last word if he would like it.
I'd just say that what we're balancing here is the incredible volume of people who don't recognize that they have a legal solution to their problem, don't turn to the system, turn to alternative, sometimes violence, compared to the prospect of other people learning that there's an avenue where they might be able to abuse the system, and then maybe our responsibility is to build in safeguards for that not to happen.
Oliver asked for one last word. So
One last word, by the way. Those of you who are interested in writing in this area, as I've urged, my Vermont Law School colleague Rebecca Purdom and I are editors of the new journal Innovation in Legal Education on SSRN. We would welcome submissions. Please, if you submit to SSRN, make sure you, in this field, you think about us and check the box for innovation in legal education. Thank you.
thank you very much.
So that ends the symposium. If you saw something today that you think, wow, I wish some of my colleagues could have been there, they can be. They are literally on YouTube right now, and you can send the links to people and say, you should watch this. You will be as inspired, at least inspired as I was today. I learned an enormous amount from these folks. And so, spread the word, use your social media and/or, use email.